Hello, my name is Helen Collins, and I am the Advocacy Support Worker with North Munster Citizens Information Service. I'm going to speak to you today about the rights and entitlements that employees in Ireland have. The purpose of the talk today is to give a brief summary of the rights and entitlements that you have as an employee under various employment legislation in Ireland. If anyone has any further questions, please don't hesitate to contact our service. And by way of a brief introduction, employees in Ireland have many different rights relating to their employment. Rights are governed by employment legislation, and I'm going to take you through the main points of the main pieces of employment legislation today. So the first question to be answered is whether I am an employee or not. You are an employee if you are engaged under a contract of service. If you have this type of contract, you are protected by the full range of employment legislation. The term contract for services is generally used where an employer is engaging an independent contractor or self-employed person for a job. If you have this type of contract, you may not have the same rights as an employee under employment legislation. If you are unsure whether you were employed under a contract of service or a contract for services, you can contact the Office of the Revenue Commissioners. Now, the national minimum wage. In Ireland, the national minimum wage for an adult employee is €10.50 per hour since the 1st of January 2022. Lower rates may apply if you are younger. For example, a person aged under 20 may get paid less than the national minimum wage. The national minimum wage doesn't stop an employer from offering you a higher wage. You cannot agree to be paid less than the minimum wage or to do unpaid work unless you are employed by a close family relative or are on a recognised apprenticeship. Employment regulation orders, registered employment agreements, and sectoral employment orders set minimum rates of pay in certain industries, for example, construction. Now, the maximum working week. In general, your maximum average working week cannot be more than 48 hours. But this does not mean that you can never work more than 48 hours in a week, but rather that your average weekly hours over a period, normally 4 months, should not exceed 48 hours. Now, there are some exceptions to this, including members of the Gardaí, who are the Irish police force, the defence forces, employees who control their own working hours, and family employees on farms or in private homes. The average working hours equals the total hours worked each week, averaged over a set period. This set period is normally 4 months, but it can be 6 or 12. Now, statement of terms and conditions. If you work for an employer for a regular wage or salary, you automatically have a contract of employment. You must be given a written statement of 5 core terms within 5 days of starting your job. These 5 core terms include the full name and address of the employer and the employee, the expected duration of the contract, the rate of method of calculating your pay, and the pay reference period. For example, whether you are paid weekly, fortnightly, or monthly. And finally, what the employer reasonably expects the normal length of your working day and week to be. For example, 8 hours a day, 5 days a week. Within 2 months of starting work, you must get a written statement of your remaining terms and conditions of employment. And these include the place of work, the job title or nature of the work, the date the employment started, pay intervals, for example, weekly or monthly, any terms or conditions relating to the hours of work, such as overtime, details around paid leave, including annual leave and your public holiday entitlements, sick pay, pension and pension schemes, the period of notice to be given by employer or employee, and finally, details of any collective agreement that may affect your terms of employment. A statement of pay. You must be given a pay slip with each payment of wages. A pay slip will show you your gross wage and details of all deductions made. Your employer must have your permission to make deductions from your wages unless such deductions are allowed by law. For example, income tax, which is PAYE, social insurance, which is PRSI, and the universal social charge. Now, breaks during your working hours. You are entitled to take breaks while you are at work and have rest periods between working days or nights. You are entitled to a daily rest period of 11 consecutive hours per 24-hour period and 1 period of 24 hours rest per week, preceded by the 11-hour daily period. In other words, your usual 11-hour break followed by a whole day off. In general, you are entitled to a 15-minute break when you have worked more than 4.5 hours. If you work more than 6 hours, you are entitled to a 30-minute break, which you can include in the first 15-minute break. Your employer does not have to pay you for these breaks, and they are not considered to be working time. Now, the right to disconnect. As well as your right to take adequate breaks, you also have a right to disconnect from work outside of normal working hours. The Code of Practice on the right to disconnect is effective since the 1st of April 2021 and applies to all employees, including people who are working from home. It gives guidance on the right to disengage from work outside normal working hours. And while failure to follow the code is not an offence, it can be used in evidence in a case taken to the Workplace Relation Commission or the Labour Court under employment legislation. Now, we'll discuss leave from work. Annual leave. Most employees are entitled to 4 weeks paid annual leave per year. However, your contract of employment may give you more annual leave than the statutory entitlement. There are 3 ways to calculate your annual leave. And then public holidays. All full-time employees are entitled to 10 public holidays each year. Now, previously, there was only 9 public holidays. However, in 2022, a once-off public holiday took place on Friday, the 18th of March. And from 2023, there will be a new public holiday in early February to mark St. Bridget's Day. To qualify for pay or a paid day off on a public holiday, part-time employees must work at least 40 hours in total during the 5 weeks ending on the day before the public holiday. If you have to work on a public holiday, you are entitled to one of the following, which is decided by your employer: a paid day off on the public holiday, a paid day off within a month of the public holiday, an extra day's annual leave, or an extra day's pay. If you work part-time and the public holiday falls on a day that you do not normally work, you are entitled to 1/5 of your normal weekly wage for that day. Now, protective leave. You are entitled to certain statutory protective leave, such as maternity leave, paternity leave, parental leave, parents' leave, adopted leave, and carers' leave. There are specific rules for each type of protective leave, and you must comply with the required notice periods, which I'll just take you through very briefly. So firstly, maternity leave. You are entitled to take 26 weeks maternity leave from work while you are having a baby. Your contract of employment will state if your employer will pay you while you are on maternity leave. Now, this is not a requirement. You may also be entitled to maternity benefit, which is paid by the Department of Social Protection. You are also entitled to take up to 16 weeks of additional unpaid maternity leave, which is not covered by maternity benefit. And then we move on to paternity leave. So for new parents, normally the father or the partner of the mother, or in the case of adoption, the parent who is not taking adoptive leave, are entitled to 2 weeks paternity leave from employment or self-employment following the birth or adoption of a child. Your contract of employment will state if your employer will pay you when you are on maternity leave. And as with maternity leave, this is not a requirement. You may be eligible for social welfare payment, paternity benefit. And then parental leave. Since the 1st of February 2020, each parent is entitled to 26 weeks unpaid parental leave. You must take parental leave before the child is 12 years of age or 16 years of age if the child has a disability. In general, you must have been working for your employer for at least 12 months to be entitled to parental leave. Parents' leave. Each parent is entitled to 5 weeks leave during the first 2 years of a child's life, or in the case of adoption, within 2 years of the placement of the child with the family. You may also qualify for a payment called parents' leave during parents' benefit during parents' leave. Adoptive leave. One parent of the adoptive couple or a parent adopting alone is entitled to 24 weeks adoptive leave beginning on the day the child is placed with you. Employers do not have to pay you for adoptive leave. You may be entitled to adoptive benefit. You are also entitled to take up to 16 weeks additional unpaid adoptive leave, but this period is not covered by adoptive benefit. And finally, carers leave. You are allowed to take unpaid leave to provide full-time care and attention for a person in need of care. The minimum statutory entitlement is 13 weeks and the maximum is 104 weeks or 2 years. Generally, you need 12 months continuous service with your employer to get carers leave. And if you have enough PRSI contributions, you may be eligible for carers benefit. If you do not qualify for carers benefit, you may qualify for a means-tested payment called carers allowance. So we're now looking at safety in the workplace. Your employer is responsible, as far as is reasonably possible, for ensuring that you have a safe workplace. This includes protection from violence at work, harassment, and bullying. Minimum notice periods. You have certain entitlements if you lose your job. These relate to notice periods and pay for annual leave that you have earned but not taken. If you are leaving your job, you must comply with the notice periods in your contract of employment. If your contract of employment does not state a notice period, you must follow the terms of the Minimum Notice and Terms of Employment Working Acts, 1973 to 2005. The requirement will depend on how long you have been working for your employer. So, for example, if you have been working for your employer for up to 2 years, you will be required to provide 1 week's notice. Now, redundancy and dismissal. Redundancy generally arises where your job ceases to exist. Employees who were made redundant from their jobs have certain entitlements. To qualify for a statutory redundancy payment, you must have 2 years continuous service with your employer, and meet other criteria. Now, dismissal occurs where you lose your job, but the position remains open and could be filled by somebody else. Reasons for dismissal can be fair or unfair. Normally, you must have at least 12 months continuous service with your employer to bring a claim for unfair dismissal. If an employee has been in employment for 12 months and is dismissed, they can bring a claim for unfair dismissal to the Workplace Relations Commission. Now, asserting your employment rights. If you have a complaint about your employment rights, you should first speak to your employer. If you cannot resolve your complaint informally, you can make a formal complaint to the Workplace Relations Commission using its online complaint form. I cannot stress that the best option is to resolve all issues locally and informally prior to taking a complaint. Depending on if you are unable to resolve the issue with your employer and decide to take a complaint to the WRC, depending on your complaint, you may have to take pre-complaint steps, such as gathering supporting documentation and sending them to the WRC as part of the complaint. For example, if you are making a complaint under the national minimum wage, you will need to request a statement of earnings from your employer before you take a complaint to the Workplace Relations Commission. You should make your complaint to the Workplace Relations Commission within 6 months of the alleged incident. This time limit can be extended by a further 6 months if there was a reasonable cause for the delay. Now, your complaint may be dealt with by mediation or adjudication. If both parties agree to mediation, a mediator will help you reach a mutually acceptable agreement. This method often prevents complaints from reaching the stage of a formal court hearing. With adjudication, there is a public hearing and an adjudication officer will make a formal judgment. If you are happy with that decision, you can appeal it to the Labour Court. In general, appeals should be made to the Labour Court within 42 days. If you do not appeal the decision within 42 days, it becomes legally binding and can be enforced through the district court. So there ends our very brief tour through employment rights in Ireland. Thank you all very much for being here today, and have a lovely day. Take care. Bye-bye.